Okay, look, no. Here's the thing. I don't mind trying to find a way, pretty much everybody in this room that's involved in the system, try to have you work this out and try to assist you to try to get past something. But if you don't want to answer my questions, you want to skate around everything, I don't have time for it. So here's what I'm going to do.
Probably a couple of times a month.
Well, now you want to answer me, right? Do you have a client?
Yes, Your Honor. This is Matthew Mansour, Assistant Public Defender with and on behalf of Mr. Exton, who's approaching to my right. State your name for the record, please.
Deja.
All right.
Your Honor, there was a community corrections report dated April 9th. You have a copy of that.
I do. What were we? Really?
Your Honor, I'll address this right now. We have no excuses. We will not.
Mr. Allen?
We will not and will never mislead this court. She takes full responsibility for her actions. She thanks this court for allowing her to remain out of custody and to continue to test. You have been fair with her. You've been sympathetic with her. She sincerely apologizes for her actions. I hope the court sees that there is something to be said about her appearance here today to take responsibility. And this is her first positive test since her very first test back in November.
Well, except for the fact that I have abnormal creatinine
I know.
throughout all of these tests.
Yes, Your Honor, that is absolutely true.
Okay.
I don't know what the creatine is. I don't know what could cause
But
creatinine, whatever. I don't know what that is. But I do know what cocaine is, and that is.
okay, well, I don't know if you should say that out loud, but go for it.
I do know that she did test for cocaine on her last attempt on the 9th, and the last time she's
I
tested.
will usually see abnormal creatinine so that you know when somebody is masking a test. Not always the case. So you can place in perspective that I have missed test, abnormal creatinine, and then finally it almost appears wasn't masked enough and the cocaine gets picked up.
Understood, Your Honor. We've been doing this for enough time to know that. I just want to let you know.
You have been doing it, or are you saying me?
You, Your Honor.
Oh,
I know.
so now you're calling me old. Go for it.
Oh,
Keep going. You're doing well.
didn't mean to do that. Your Honor, I just would ask this court any leniency possible. I know you know her situation.
I do, but the problem is that then come here today saying all of that, but that's not what she told community correction.
Well, Your Honor,
She denied use to community correction.
Your Honor, she's stating that she did not deny use. Okay, there's a positive test. That's what we're here.
Hold on a second. You want me to get community corrections over here?
Would that help?
Not you, I don't think. She's denying use to community correction. You have the report in front of you, counsel?
Yes, I do.
Look at the box.
Yes, I
What's
see
it
it.
say?
It says denies use. That was,
She's saying that didn't happen.
yes.
So she admitted use.
Now she's admitting use.
No. But she's talking to community corrections. What did she tell community corrections?
Can I speak?
You can do it. Hey, it's
So
up
when
to
the lady-
you.
So before Agent Carr called, the lady called and said it was a illicit drug. I told her I didn't know what illicit, I said, what is illicit drugs? And she said, I can't tell you the exact what it is. Call your agent. And when I called Agent Carr and she said what it was, I told her, okay. So I never denied it, but the lady that called from the lab called and just said illicit drugs. And I didn't know what illicit drug was. So that's probably what I came in contact, but I mean, you could ask Agent Carr. I definitely didn't deny yours. Once I talked to her.
So then how did the cocaine get in your system?
What you mean? How did it get in my system?
Yeah.
Took it.
When?
When? Like, I don't know, a couple of days before.
Anything else?
And the abnormal creatinine, I mean, that pops up. I have kidney problems. So that I got a report on it. She wanted. So, I mean, that been in a lot of my tests and all the stuff still pops up. It's literally in almost every test that I had. But things still popping up from stuff that I'm prescribed and the cocaine.
Anything else? What are we doing with this case?
Well, Your Honor, I spoke with Mr. Ganatra. He was kind enough to honor the offer made the last PCC. I was just trying to ask this court if it had any leniency for this situation.
To do what?
Excuse me?
What were you asking me to do?
Your Honor, I'm asking for any leniency for this bond violation.
Okay, so on March 14th, she was here. I told her no more missed tests, right?
Yes, you did.
I also gave her an admonishment about how she was treating the people. I'm trying to think at what date I had to do that. Back in December, she was mistreating the people over at Community Correction.
That'd be the 11th.
In December.
Yeah. December 11th, bond violation.
And then don't make it a few months. And then I have to tell her, don't miss tests. And then she tests positive.
Your Honor,
She just seems to do what she wants to do herself.
you wanted me to let you know that she's struggling. And she has a special needs child at home and going through a lot. So
The cocaine helped.
no, obviously not. Look where we're at.
What were you going to do with the case itself? No.
Yeah. Oh, but gosh.
So there's a plea offer, but I've not written up the plea form while she's got.
Yeah, that's not going to happen today. How often are you using? Now, young lady, you can, as your counsel has indicated, I guess I'm old and I've been doing this a minute. So you can go ahead and tell me what you want to tell.
I mean, I don't want to tell you anything but the truth. I take responsibility for it. And
How often are you using?
Like, you want to, like, is it an everyday thing?
I don't know that that's a hard question.
I have a problem with it. I stopped it and I started back.
Was that my question?
But a couple times.
Okay, look, no. Here's the thing. I don't mind trying to find a way, pretty much everybody in this room that's involved in the system, try to have you work this out and try to assist you to try to get past them. But if you don't want to answer my questions, you want to skate around everything, I don't have time for it. So here's what I'm going to do.
Probably a couple of times a month.
Well, now you want to answer me, right? I'm going to adjourn the probable cause conference. I'm going to adjourn it out 1 week to the 18th, 2024 at 9 a.m. This time, given the violation, you think about what you really want to say. Defendant's bonds revoked, defendants remain. Court calls case People versus Desir Exton.
People.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Exton. Here's my right. Exton, can you state your name for the record, please?
Deja Exton.
I have before me a plea form that indicates that the defendant would be pleading guilty to added counts 3 and 4. 3 being attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. And count 4 being use of a controlled substance, also the 1-year offense, also a 1-year offense. On her successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's entire understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give the truth, nothing but the truth, so help you God.
Yes.
State your name.
Deja Exton.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct? First is the charge and added count 3 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon. You understand that?
Yes.
Count 4 is use of a controlled substance. That is also a misdemeanor punishable by up to 1 year incarceration and or $2,000 fine plus court costs. Do you understand that?
Yes.
You also understand, ma'am, while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
Still wish to plead guilty
Yes.
to the charge of attempted possession of a loaded firearm in a motor vehicle? How do you plead?
Guilty.
To the charge of use of a controlled substance? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form today. Is that correct?
Yes.
Any questions regarding any of those rights? Please look at paragraph 5 on that form. Those are your rights which are part of a trial. By pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily of your own free will
Yes.
because you believe that you are indeed guilty of these offenses?
Yes.
On May 22nd, 2023, at the location of Tower in near Ann Arbor. Yes, okay. In the city of Saline, Washington County, state of Michigan. Were you in a motor vehicle?
Yes.
Did you have a weapon in that vehicle?
Yes.
What was it? Was it a pistol?
Yes.
Where was it located?
Under the seat. I mean, in the Kia Soto.
I'm sorry?
In the car, in the Kia Soto.
Got it. You don't have authority to carry a weapon in that fashion. It was in the passenger compartment, correct?
Yes.
You don't have permission to carry it in that fashion that you were carrying it, do you?
No.
All right. Did you also have in your possession heroin and or fentanyl?
Yes.
Had you used it?
Have I used it? Yes.
Had you used it? Okay, and you knew what you were using was heroin and or fentanyl?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
That's satisfied, Your Honor.
Court will accept the defendant's plea of guilty. 2 counts 3 and 4 counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
April 23rd at 9 a.m. before Judge Freshour.
April 23rd, 2024, 9 a.m. before Judge Freshour.
At this point, the legal picture has changed completely. Just a short time ago, the defendant was facing a bond violation after testing positive for cocaine and repeatedly frustrating the court's efforts to keep her on track. Now she's formally pleading guilty to reduced misdemeanor charges involving a loaded firearm in a vehicle and controlled substance use. Notice how plea negotiations work in practice. The prosecution agrees to dismiss more serious counts in exchange for a guaranteed conviction, while the defendant avoids the uncertainty of trial. But here's the real question. Does entering a guilty plea automatically mean someone deserves another chance at freedom before sentencing, or has this defendant already used up too much of the court's patience? Let me know what you think, because the bond discussion coming up is where things get really interesting.
Your Honor, my client would like me to address bond.
Go ahead, briefly.
Thank you, Your Honor. Ms. Exton is Michigan born and raised. She's a Detroit resident. She's a full-time mother with full-time custody of a 3-year-old daughter. She works full-time at Amazon at the Brownstown location. She's not sure if she still has that job, but she's been employed there ever since November. To my knowledge, she has no open criminal cases. She's not on probation. She's not on parole. Her iChat is clean. Her record of appearances in this court, she's never missed a date. She does not own or possess any firearms. She has no plans to leave the state of Michigan anytime soon. We know she has not been perfect while testing on bond. She has spent the entire week in jail. She had a lot of time to think and reflect on her mistakes. All this time away from her child. Her 80-year-old grandmother is struggling right now, trying to help take care of that child. Your Honor, I'm asking for a PR bond on her behalf, allowing her one final chance to show you that she has learned from her mistakes, and she personally would like to apologize to you herself.
I can speak. Oh,
If you'd like.
I apologize for the way my attitude been perceived in this court.
Perceived?
I mean, I apologize. That's not who I am. I had a lot of time to reflect on my actions, and I learned my lesson. I don't want to be that person.
Your Honor, can I speak?
I don't know who you are.
Oh my God.
Yelling from the, who is that? Who are you?
I'm my mother.
Go ahead, man. I need your name.
My name is Heather Gregory, then you're right next to mother. I'm here because she do have a 3-year-old child that's a special needs child. I work all the time, over 60 hours. I just came back from out of town, and my mother is struggling to take care of her daughter, by herself, because we just lost my father. If we gotta have on a tether or whatever, Your Honor, we definitely need her home, because my mother cannot take care of the child, and I work too much.
She explained to you what she did?
She did.
She did not?
She did not. She did not.
Okay, let me just put it to you this way, Mom. She's in custody because she worked her way there. I mean, it wasn't just where I just threw her in. She was coming, she had issues over with an attitude problem over at Community Corrections and doing stuff there. I gave her a warning. Didn't lock her up. She was supposed to be testing. She was supposed to be doing everything. Next thing I know, she shows back up here, and she not only has abnormal creatinine levels, which would be positives at any event. I was still giving her the benefit of the doubt, but then shows up with cocaine in her system. That's how she ended up locked up. So the difficulties are not because of anything the court's doing, it's because of what she's not doing and then not telling me the truth.
I understand. I mean, like I said, I didn't know the full extent. I've been out of town, I went out of town in and out. So I didn't know what happened, but she was court, I know you had locked her up. And like I said, she got a special needs kid, a daughter that has cerebral palsy, my mother trying to take care of. And it's hard. I know she's not perfect, and I know she has an attitude
Oh, yeah, she does.
problem, which, I mean, she might have got it from me, but I definitely need her home because I got this grandchild that needs her. So over all that, Your Honor, I'm just asking, can you please give her another chance? If I gotta watch her, I will, but I definitely need her home for my granddaughter's sake.
This is one of those moments where the judge is weighing far more than just the legal paperwork. On one side, there's a mother asking for another opportunity, a family struggling to care for a young child, and a defense attorney emphasizing employment, community ties, and a history of appearing in court. On the other side, the judge has already seen missed opportunities, prior warnings, attitude issues with community corrections, abnormal test results, and a confirmed positive cocaine screen. In bond decisions, judges often look at compliance and credibility just as much as the underlying charge. If you're sitting in that courtroom chair making the decision, what matters more, the defendant's recent mistakes or the possibility that she's finally ready to turn things around?
Any response from the people?
No.
Thank you. Thank you, Mr. Gunnar. Outside of that, Mr. Why should I even bother letting you out? Because I just have a feeling what's going to end up happening is Judge Freshour is going to have to lock you right back up.
I'm not gonna be the person that I was. I had time to think in jail, trust me. I don't wanna be there.
Their previous month. Of course, messing everything up.
Post the previous one.
Mhm.
$5,000.
$5,000 personal recognizance bond. I'll reinstate previous conditions.
You need to thank him.
Thank you, Joe Simpson.
Thank you,
You
Ron.
what?
She would get a different date.
Yeah. Different. But hold on. Reinstate the previous conditions. Also indicate that there's to be no further tests. I will also order a GPS tether. Home confinement, except work.
Your Honor, can I get that date one more time if it changed? For
I
sentencing?
didn't give it to you yet.
I'm sorry.
Sentencing date now will be one. May 14th, 2024, 9 a.m. before Judge Freshour. Be sending a note to Judge Freshour, so young lady, if you mess up one bit.
This case ended with a result that very easily could have gone the other way. The defendant admitted guilt to misdemeanor offenses involving a loaded firearm in a vehicle and controlled substance use. But the biggest issue throughout this hearing wasn't the plea itself. It was trust. The court spent much of the proceeding examining her conduct while on bond, including a positive cocaine test, prior warnings, and concerns about honesty and accountability. Despite all of that, the judge chose not to keep her in custody and instead reinstated bond with significantly stricter conditions, including GPS monitoring and home confinement. That decision sends a clear message. This is a final opportunity, not a fresh start. One more violation could put her right back behind bars before sentencing. What would you have done in the judge's position? Would you have granted one last chance or revoked bond completely? If you enjoy real courtroom drama, legal analysis, and the moments that can change a defendant's future in seconds, make sure to like this video, share your thoughts in the comments, and subscribe to the channel for more unforgettable courtroom breakdowns.